I'm Phyllicia Tanenbaum, and I'm an associate in the corporate and transactional group at Fluet in Tysons, Virginia. I counsel clients in various industries, including government contracting, technology, aerospace, and defense. I help businesses with lending, mergers and acquisitions, reorganizations, and private investment and venture capital deals. I am here with a partner in our corporate group, Eric Kronman. Eric, why don't you tell us a bit about your background?
Thanks, Felicia. It's a pleasure to be here. I'm Eric Kronman. I'm a partner at Fluet in both the corporate and transactions group as well as the government contracts group. I started my career as a pure venture capital and M&A lawyer before going in-house to a large government contractor, where eventually I became the general counsel of a handful of larger GovCons, before returning to private practice, where I now support high-tech companies, government contractors on everything from corporate governance, transactions, teaming, employment issues, incentivizing employees, and still spend a lot of my time on those same transactions like venture capital investments, loans, and what we're here to talk about today, mergers and acquisitions.
Yeah, thank you, Eric. We are here to talk about our corporate and transactional practice, which encompasses general corporate advice, transactions, and governance. For now, I want to talk specifically about sell-side M&A, where, for example, we have an entrepreneur-founded company, whether it be a GovCon, high tech, or otherwise, that is looking to sell in the coming year or two. For this example, they're not yet at the LOI stage, but want advice on how to prepare for a sale in the next year or two. Eric, how would you advise them at this stage?
It's always great when a client approaches you, before they've entered into an LOI or, before they've already, hindsight's always 2020. So you see a lot of times we're getting at a lot later stage and sometimes it's too late. So if they're approaching us at the stage that you're talking about, it's wonderful. Working them with the client about their goals, financial, if it's an entrepreneur-backed company, like you mentioned on the sell side, career-wise, what does that entrepreneur founder want post-deal? What about their employees? What about other owners? Do we want to set up incentives or a certain structure to make sure that they're rewarded, thanked, incentivized for getting through the transaction? Before we enter the process, we also want to make sure that corporate governance and records, that they're all in good shape. We typically assist sellers with a dry run through the same types of due diligence that buyers will ask for, so they understand what needs to be prepared, what issues they may face. A lot of times you'll do this by the same way that a buyer would look at you of, show me your top cash inflows, your top cash outflows. Let's see the corresponding contracts with that. Do any of these contracts have anything that would make it harder to do either an asset or a stock deal? Do they have any clauses like a most favored nation clause, something that would give heartburn to the buyer down the road? We also help them understand their backlog, their contract life cycles, their contract types, when is a good time to sell, and talk to them about what makes their company attractive or unique in terms of licenses, capabilities, et cetera. Those are things that we do that also you'll see, if they have a banker involved, a banker would also kind of assist with that process.
Yeah, that actually leads to my next question. So at Fluid, we do some deals with bankers and some without. Eric, what are your thoughts if a client at this stage asks whether it should interview and potentially engage a banker?
Yeah. So the bankers are great at organization, sophistication, adding value. When you're representing a sell side client, there's a handful of them that are repeat entrepreneurs, and this is their fifth or 10th time. But for the most part, there's a lot of wisdom. There's a lot of advantage of being on the buy side, whether it be private equity, whether it be strategic, where they've just done this much more than the sell side founder entrepreneur. Having a banker involved does two things. One is it evens out that sophistication level where the banker representing their best interests has that same amount of deal flow, sophistication, wisdom as you're seeing on the buy side. And the other piece is a lot of times a client will approach you that they've already had a potential acquirer reach out to them, perhaps even have an unsolicited offer. They already have in mind who they want to sell to, and they're attracted to that deal. But if they want to be able to sleep at night and know they got top dollar, the banker will run a process. They'll help them get organized, much the way we were talking about before. They'll put together a SIM, a confidential information memorandum, and they'll run a process where they'll get to look at many potential buyers. And through that, they'll know that they didn't leave money on the table. So yes, a banker will cost a handful, a few percent when the transaction closes, but they'll certainly know they got top dollar, and they'll go into it a lot more organized. So depending on the client, a banker can certainly be advantageous.
Thank you, Eric. You mentioned a sim. Can you get into a little bit about that stage and the next stages?
Sure. So once the client decides they want to sell, they've hopefully gotten organized, they've perhaps already put in place, a phantom equity plan or some sort of transactional piece to incentivize the next level down of folks, and they're moving forward with the process. So whether it be with a banker or on their own, with a banker, the banker will put together this SIM and have an NDA where a bunch of potential buyers, both strategics and private equity funds, we'll take a look at the very high level summary of this business and decide, do you want to know more about this business? If so, sign on and we'll give you more details and access to a data room. At that stage, they'll then, be accepting LOIs or, basically term sheets where the buyers will outline, yes, we're interested in buying you, and here's the structure that we'll put forth. So that's called a letter of intent or a term sheet. Those are typically non-binding. Sometimes confidentiality will be binding or some exclusivity period, but for the most part, it just lays out a framework of what will go into the deal.
So, Eric, obviously, when we represent buyers, they tend to have more wisdom and experience in M&A transactions, whereas on the sell side, this is often an entrepreneur's first time experiencing this. How does this come into play during the LOI stage?
Right. So as we mentioned, the LOI is just setting the table for the eventual deal. For the most part, it's non-binding, but it's still setting the table of how the transaction will work, what both sides should expect. And then as we get towards the later definitive documents, either an asset purchase agreement, stock purchase agreement, merger agreement, however this deal is structured, we'll go back again and again to the high level business bullet points that the buyer and seller agreed to. A real heuristic is that buyers want them to be short and sweet, the LOI, and sellers want details. And there's certainly an advantage. In 95% plus of deals, the buyers present the first draft of definitive documents. And there's a real advantage in that, yes, they'll follow the term sheet and LOI, but anywhere there's gray area, anything that's not covered, they'll make buyer favorable. Examples of this you'll see are working capital, where the buyer will say reasonable working capital upon closing. And the seller knows exactly how much working capital they've had, right? They know exactly what their AR is at given times, their AP, and they'll say like, we want a target, but we don't want it to be excessive. Another thing is how you deal with the definition of indebtedness in the deal. Every M&A deal, if you think about it, is you'll hear all the time, it's on a cash-free, debt-free basis, where you're buying the enterprise value of the company, but if the company has a lot of excess cash, that increases the value, or they take the cash out before closing. If it has a lot of debt, you're paying the enterprise value minus the debt. Most buyers and sellers understand that concept. The piece where the buyers, especially the more sophisticated ones, sometimes take advantage of sellers is things that count as indebtedness that people don't think of as indebtedness. A good example of this is deferred revenue, or some people call it prepaid revenue. So take for example, this entrepreneurial hypothetical company. They sell SaaS either by the subscription model, or just sell services in advance where they collect the cash in advance, they'll perform the services later. That sounds like a great company you want to buy, a company that doesn't have any issues collecting cash because they've been paid before they did the work. The problem is when you go to sell that company, the buyer is going to treat that as cash you already sent out the door, and they'll say that that's indebtedness, and they'll subtract dollar for dollar every bit of revenue you've already collected, or sorry, cash you've already collected for work you've not yet performed. So in the LOI stage, you want to make sure you have sufficient detail that you're taking care of the buyer and the seller both knowing and agreeing how we treat this. So very often, if it's vague and if it's short, the buyer later on will ask for a dollar for dollar reduction for every dollar of working capital, sorry, every dollar of deferred revenue. And on working capital, ask for an unreasonably high target. Both those things are, cash adjustments where the seller is getting less money for their company than they otherwise thought. So the more we can address that at the LOI stage, create detail, maybe even give examples, the better. The other part you want to make sure at the LOI stage are working through consideration and when and how it's paid. You know, they sometimes get the buyer will offer a big attractive number, but a lot of that is going to be earnouts or money you get later should you hit certain revenue or earnings targets. Um, you want to know, uh, you know, while choice of law and venue are not super important at the LOI stage, again, it's still setting the table for what we choose now will be likely what we agree to later at the definitive document stage. So a lot of these things you want to make sure you're covering now, you're understanding exactly what the deal is, how the cash flow works, and then a lot of founders want to make sure you're also taking care of and what happens to them individually. How long are they still part of the company? Do they have an employment agreement? If there are earnouts, do they maintain control during that earnout period? And these are things being detailed in the LOI really benefits the seller, even though it is more time and expense at the early stage. It really makes for better deals and deals a lot more likely to close down the road.
Thank you, Eric. Can you please describe what happens after the LOI stage?
So after both parties sign their LOI, a lot of times they're now in a period of oftentimes exclusivity, where, hey, for the next 6, 8, 10, 12 weeks, buyer, you can start doing due diligence and we're not going to keep shopping ourselves other buyers during this period. Sometimes there's not that type of exclusivity. But yeah, at this stage, buyers simultaneously conducting more detailed due diligence. That sim we talked about gives them very high level information about the company, but now they actually get to dig in. Usually we'll have, by that point set up a data room. They'll have given a due diligence request list, and we help the client in organized fashion, organize that diligence and show the buyer what they're getting at. Um, Simultaneously, the definitive documents are being now drafted by the attorneys. And here's where I mentioned the buyer has an advantage of anchoring those documents in a buyer favorable way. Again, getting back to the importance of including some detail in the LOI when you're the seller. At this stage, it's important to remember that the seller is still managing their day-to-day business. So, they don't have the bandwidth of the time to necessarily be full time on this transaction. Um, so this is where having a banker, having your lawyers understand your business, understand your goals, that those things we did even before the LOI stage really come into play here to keep driving the transaction forward as we enter this stage. Now, in the definitive documents, we're not only making sure that we honor the LOI terms, but we're also now negotiating what's called the reps and warranties. Representations or promises that this is true now, a warranty is this will be true in the future. There's also covenants that the buyer promises they'll do X, Y, or Z in the future. Usually those are negative covenants saying, after this transaction for a period of a certain amount of time, I will not compete, I will not solicit, either customers or business. You'll also see indemnification provisions and limitations of liability, where if any breaches of warranties, representations, covenants happen, how does the seller get money back from the buyer, or perhaps take money from, if all the consideration wasn't paid up front, perhaps some of it's escrowed or held back. And then we also see limitations of liability. And those we negotiate to make sure that the buyer's not being nickeled and dimed, or that at some stage the buyer has a cap to how much they would have to give back or not receive in consideration. So these are the important parts of, it seems like a lot of legal language, but we always try to remind our clients, our job as your attorneys are to maximize the value you're getting, to get you that maximum consideration as soon as possible, and then to limit, when we're representing a seller, to limit the buyer's ability to either withhold paying later payments or to limit their ability to claw back those payments. And you do that by negotiating custom tailoring these reps and warranties, by making sure you have effective indemnification provisions, and then by having meaningful limitations of liability. So, in short, we're just making sure the seller's only making promises that it can keep and stand behind, and the buyer's ability to claw back money or not pay full consideration is as limited as possible. And that's what's going on in the definitive document stage.
Can you talk a bit about disclosure schedules?
Sure, sure. So, in any legal document, whether it be an investment, whether it be, in this case, an M&A deal, Both parties make representations, warranties, covenants. For the reps and warranties, rather than custom tailor every rep and warranty to the exact deal, the parties, in this case, the seller will make all kinds of reps and warranties, saying that we have no contracts that have a most favorable nation's pricing clause, right? That could be true, but if we become aware in diligence there's actually two contracts where that's not the case, then we'll disclose to the seller, to the buyer rather, that yes, this statement is true, except for these two contracts, and we'll give sufficient explanation. And when you get to those indemnifications, what happens is we are indemnifying any breaches of reps and warranties except for those which we disclosed. So they can no longer sue. They've been made aware that there are exceptions to the reps and warranties. So, disclosure schedules have two purposes. One is that exceptions clause, and another one's information. You'll also see a lot where they'll say Exhibit XYZ includes the financials, the income statement and the balance sheet for the last 2 fiscal years. Or Exhibit ABC gives a list of all employees, in a spreadsheet format, listing their titles, their compensation, maybe what contract they're tied to, things like that. So the disclosure schedules are just an extremely important part. And then if you go through it, you take it seriously, especially the exceptions part, you greatly limit the ability of the buyer to claw back money later. You limit there being a dispute down the road, and it's just making the seller that much safer that the consideration they have, they get to keep.
Sounds great. Thank you, Eric. Finally, can you talk a little bit about closing and post-closing events?
Sure, sure. So, many of these deals we're gonna have a simultaneous sign and close, which means, we've already had the LOI that's setting the framework, setting the table, and then we'll negotiate these definitive documents, whether it be an asset purchase, stock purchase, merger agreement, and you know, we'll have a closing where we exchange signatures to these definitive documents when they've been fully negotiated, and then, have a flow of funds where the money from the buyer will, hit the seller's account, pay off debt, pay off deal expenses, and then it'll flow down to the shareholders, in this waterfall as determined by this document. Sometimes we'll have non-simultaneous, what's called a separate sign and close, and those are usually for reasons of, let's say it was an asset deal and it's a government contractor. As all the government contractor clients out there are aware, in a stock deal, their contracts are still owned by the same company. If you do an asset deal, you have to technically novate those contracts over. So if a buyer's buying the assets, which again, why do buyers want to buy assets in a deal? Is they don't have to take all the unknowns in a stock deal. They get an automatic step up in basis. And again, oftentimes we'll also see, I'll call a hybrid, a 338H10, where you can buy a company in a stock deal and then still get the step up in basis in an asset deal, if certain conditions are met. But in the case of an asset deal, you often see a separate sign and close so that the buyer can confirm that the contracts they cared about or the asset they cared about successfully moved over or novated over. Sometimes it's a foreign investment, so you need to get CFIUS, Committee on Foreign Investment, U.S. approval. Oftentimes it's a large deal, when you hit that 9-figure amount. HSR, Hart-Scott-Rodino, which is the antitrust pre-merger notification. So there's certain reasons why, for regulatory reasons, asset transfer reasons, that you need to have separate sign and closes. So that is kind of the piece on the closing. You also ask, what's next? So post-closing, what's next for the seller? Well, we always try and remind folks that this is not a zero-sum game. Throughout this entire process, the buyer and seller, they hopefully have a very large zone of potential agreement where the buyer's feeling they're getting a great deal, the sellers are feeling they're getting a great deal. And yes, they are opposite the table and negotiating against each other right now, but they're both coming out of this as winners. It's not a zero-sum game. So always reminding folks that after the transaction closes, we're all on the same team, especially deals where the seller is now hanging around, perhaps they have an employment agreement or they're managing the business through the earnout period of a year or two. They're all on the same side. And they're all hoping that the company succeeds, with all these synergies, that the seller is now doing even better than it could have done on its own without the buyer's backing and all these other synergistic, uh, you know, elements at play here. So oftentimes the seller is now a senior executive or even a division president at the buyer. So it's always helpful to kind of talk through that, and then thinking through the earnouts. Um, you know, Earnouts should always be, when you negotiate them, objective. Sometimes when they're tied to very strange profit margins that are hard to calculate, that's not a good one. You want it to be measurable, objective, and attainable. And if the earnout meets all those things, whether it be a revenue-based earnout or sometimes you'll have performance-based earnouts, like technical deliverables. So we want to make sure that those are all achievable and can be earned. We want to make sure that the sellers still maintain a modicum of control, that they control their own destiny to earn those earnouts. And then a lot of times we also want to talk about employment agreements for the key folks at the seller to make sure that they are incentivized and protected under the new ownership of the buyer.
Thank you, Eric. We are at time. Thanks so much for these great insights. To recap, we briefly discussed key considerations for sell-side M&A, whether to engage a banker, SIM, NDAs, LOIs, disclosure schedules, closing and post-closing events. Eric, in talking with you and working with you and other colleagues here at Fluet, I'm reminded of how we are business-minded and how well our different practice groups work together. So many of our clients have unique government contract concerns, international trade issues, facility clearance responsibilities, or some pending litigation as they enter the sale process. And the whole team here really comes together to efficiently and effectively meet our clients' goals. If someone watching or hearing this is thinking about an M&A transaction, please reach out to Fluet for guidance in navigating the process as soon as possible so that we can ensure the best outcome for your interests. Thanks again, Eric.
You bet. Thanks, Phyllicia.